If you are a defendant in a case and your right of filing the written statement has been closed by the court because either you missed the deadline of filing the written statement or you have been proceeded ex parte because of your non-appearance, and further you could not set aside that order of ex parte also, and you have lost the maximum extension period. So as per order 8 rule 10 also, the judgment can be passed against you solely on the basis of plaint if there is no written statement. So in this circumstance, is there any practical way to make out a case? Because if there is no written statement, it means there are no defense pleas. You have got the allegations from the plaintiff, but you could not defend yourself because you could not file the written statement. So the foundation is very much weak for your case. So on a weak foundation also, can you make a manageable building, a manageable case? How? Let us see in this video. So first of all, the question arises, if you have not filed the written statement, can you file the evidence? The answer is no, because the logic of filing the evidence is to support the defense pleas. If there is no written statement, it means there is no defense plea. And if there is no defense plea, what will you support from the evidence? Nothing. Secondly, a party cannot be taken by shock by the introduction of new facts. If there are no defense plea, it means there are no new facts from your side, and you cannot introduce new facts later at this stage of evidence also. And Supreme Court also in two cases, number one, Harihar Prasad versus Balmiki Prasad, and number two, Ram Saroop versus Bishun Narayan Inter College, laid down the same law point that no evidence can travel beyond the pleadings. If you have not filed the written statement, it means you have no plea, that is no pleading from your side. If there is no pleading, no evidence can travel beyond pleading. So ultimately you cannot file the evidence. However, a conflicting perspective emerges due to another Supreme Court ruling, Sangram Singh versus Election Tribunal. As per this ruling, if a party has been proceeded ex parte, that is within his absence, still that party can participate in the subsequent proceedings without any permission of the court at any time. This ruling I have covered in detail in one of my previous video, which you can watch by clicking on the I button right now. So now the conflict is how one can participate if he is not allowed to file the evidence. This conflict was solved by various high courts of various states. Let us see. Then I will show this what Supreme Court says. High Court, Patna High Court in the case of Gobinda Gorbi versus Baldio Ram, which is a division bench ruling, held that if a defendant has not filed written statement, still he can file his evidence to counter the case of plaintiff without introducing any new fact. It means in simpler terms, the facts, if plaintiff has given various facts, the defendant can show only the contradictions to question his credibility, and no further facts can be introduced in those evidences. Patna High Court in another case, Shai Sinha versus Shivadri Sinha, laid that the defendant without a written statement can cross-examine the plaintiff to demolish the plaintiff's own case through the plaintiff's facts only. Defendant cannot cross-examine with his own sides of facts. It is not allowed. There is a bar on that. But still he can cross-examine. Now various other high courts, that is Allahabad High Court in the case of Gopi Charan versus Ram Prasad, Rajasthan High Court in the case of Ganpat Chand versus Jethmal, Jammu and Kashmir High Court in the case of Chunni Lal versus Bank of Baroda, adopted the same view put by the Patna High Court. Now let us see what Supreme Court says on the same point. So Supreme Court in the case of Balraj Taneja versus Sunil Madan, which is a ruling of 1999, first of all approved the Patna High Court ruling of Shai Sinha and Jammu and Kashmir ruling of Chunni Lal, and further laid down a very important law point. Before moving to that law point, the reasoning behind that was that there is a section in Evidence Act, that is section 58. If I talk about the new law, Bharatiya Sakshya Adhiniyam, the relevant provision, the equivalent provision is section 53, which states the facts which are already admitted needs not to be proved. Because the facts are already admitted, why to prove them? But even if they need not to be proved, so as per the proviso of the section, still the court can bind the party to prove the admitted fact also. So what is the reasoning behind this proviso? The reasoning is that it is a duty of a court to dig out the truth, to remove all the waters from the ocean, to see what has happened actually in the case. So as per Supreme Court, even if the defendant has not filed a written statement, court cannot pass a judgment mechanically, only relying upon the pleadings of the plaint by the plaintiff. In the absence of written statement, a court cannot presume that whatever is mentioned in the plaint is true and there are no disputes. And court must be careful in giving the judgment in this case because of technical hurdles that one party cannot file the written statement. Injustice should not be legalized. And this Supreme Court ruling was referred in various other Supreme Court rulings, one latest being in 2024, Asma Latif versus Shabir Ahmed. So now one point is clear now that even after not filing the WS, that is the written statement, a party can cross-examine, a party can lead evidence as per the rules which I have told just now to make out a case. But there is a further solution also. That is, there is one section in Evidence Act 165. Equivalent section in Bharatiya Sakshi Adhiniyam 2023 is 168. And why this provision, judge has the power to put any question to any party if there is no evidence filed, to ensure that the justice is not hindered due to the procedural shortcomings of any party. And the reasoning behind this provision is a basic principle laid down by Supreme Court that court is not an empire to decide at the end of the combat that who has won the case and who has lost the case. No. The judge, independent of the parties, has its own responsibility to play an active role to dig the truth with spade in one hand and hunter in another hand. Because every trial has not to be decided mechanically, because a trial is a voyage where truth is the quest. So for truth, anything which is possible has to be done, because it is the duty of the judge to not only to do justice but also to ensure that justice is being done. And Kerala High Court also, in the case of State of Kerala versus Kutti Madhu, held that under section 165 of Evidence Act, a judge can ask any questions at any time of any type to any party or any witness about any fact, being it a relevant fact or an irrelevant fact. And no party has a right to object on such questions put by the judge under section 165 of Evidence Act. But the problem lies here is that this provision is a discretionary provision. A judge may ask, may not ask. It is not your matter of right to demand the judge for asking such questions. But because your case is very much weak and you have not filed your defense pleas under the written statement, so it becomes important for you that the judge ask questions in your to find out the truth. But you cannot bind him to ask such questions. To how to practically invoke this provision so that the judge asks questions which you want him to ask. For this, you may consult a good advocate so that a foundation can be laid down in your case. So these are the practical solutions by which you can support your case and make a manageable case on a weak foundation even after not filing the written statement. If you have liked this video, you will like this video also, in which I have told that if an order has been proceeded against you ex parte, that is in your absence, still in the subsequent proceedings you can participate at any time without the permission of court, and there will be no cost upon you. So click here to watch that video. Meet you in the next video. Thank you very much.